Good afternoon, all. Welcome to the 24th meeting of the Joint Select Committee on National Security. We reconvene this meeting, and we want to welcome those present as well as the viewing and listening audience. This afternoon, we have a public interaction with the representatives of the judiciary, and we want to say that this meeting is being broadcast live on the Parliament's Channel 11, Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. I wish to remind members and officials that at this meeting, we direct our questions through the chair, and as part of our protocols, when you are recognized by the chair, you would speak, you will turn your mics on, and when you're finished, you will please turn your mics off. This engagement with the judiciary is an historic engagement indeed. The Parliament of Trinidad and Tobago, and by extension, the citizens of Trinidad and Tobago, are grateful for the opportunity to interact with the judiciary on this important topic of the criminal justice system in Trinidad and Tobago and the improvement of the criminal justice system in Trinidad and Tobago, and what other body will be most suited, most apposite to make submissions to enlighten the public as to the criminal justice system in Trinidad and Tobago and how it can be improved other than the judiciary. This interaction is guided by certain guidelines, and the guidelines really are to facilitate effective discourse between officials and the persons involved in the administration of justice and this Joint Select Committee on National Security. The hope is that this meeting will provide clarification and explanations for specific aspects of the criminal justice system that fall for consideration. We hope that it will provide clarification to burning issues that the public may have. The committee has already met with certain other stakeholders in the criminal justice system, and we have received written submissions from others. We wish to thank all contributors, and we wish to say that the committee remains open to other contributions made and open to the comments that will come from the public. My name is Keith Scotland, and I am indeed the chairman of this committee. I wish at this time to ask the other members of the committee, starting with the vice chair, to introduce themselves.
Good afternoon, everyone. I'm Paul Richards, Vice Chairman.
Good afternoon, Richard Sakai, member.
Hi, good afternoon. I am Ayana Webster-Roy, member.
Good afternoon, Jayanti Lachmadial, member.
The members of the support team are as follows. To my immediate left, the hardworking secretariat, Mrs. Jackie Sampson Miguel, and to her left is Mr. Brian Caesar. We are supported by Mr. Roger Hector, Ms. Meredith Brown, Crystal Gittins, and Chad Salandi. As we begin, we'd want to ask the members of the judiciary to introduce themselves, and starting, of course, with Master Christy Morris-Alain, the Court Executive Administrator, and then we will move on to the others. Thank you.
Thank you very much. My name is Christiane Morris-Allen, and I am the Court Executive Administrator of the Judiciary of Trinidad and Tobago. And I will invite my team members to introduce themselves, and if we can start with far left.
Good afternoon, all. I'm Carolyn Eagle. I'm the Deputy Court Executive Administrator for the Criminal Division.
Good afternoon. My name is Anderson Gordon, and I am the Court Planning Director at the Judiciary.
Good afternoon. Raymond Roberts, Registrar and Marshal of the Supreme Court. Good afternoon, Wendy Lewis Callender, Deputy Court Executive Administrator for the Family and Children Division.
Good afternoon, Ria Collingwood Boafo, District Criminal and Traffic Court Administrator.
Good afternoon, Siobhan Lewis, Criminal Division Administrator.
Good afternoon, Gerald Mark, Deputy Court Executive Administrator, Finance, Budgets and Procurement.
Hi, good afternoon. Rikab Ali, Deputy Court Executive Administrator, Judiciary.
Good afternoon. I'm Jamie Filbert, Deputy Court Executive Administrator for the Civil Division.
Good afternoon. I'm Carleen Cross, Children Court Administrator, Family and Children Division.
Good afternoon. Ms. Anissa Lewis, Divisional Senior Court Systems and Compliance Auditor, Criminal Division.
Good afternoon, Natalia Nurse, Children Court Manager, Family and Children Division.
Thank you very much, Madam Court Executive Administrator and members of the team. As the public will see, we have almost a plenary session of the administrative staff and the engine room of the Judiciary, Trinidad and Tobago. This is indeed a welcome event, and without any further ado, I'd want to indicate that the interaction will begin with an audio-visual presentation by the Judiciary. Judiciary, are you ready to make your presentation?
Yes, thank you. We are, Chair.
Thank you kindly.
It's up.
The criminal justice system. Did you know that the criminal justice system involves more than just the courts and the judiciary? The criminal justice system in Trinidad and Tobago includes various agencies and organizations that work together to detect and investigate crime, provide evidence, arrest and charge suspects, prosecute, defend the accused, manage court matters, and imprison, rehabilitate offenders. Think of the system as a relay race. The judiciary runs the final lap. We'll delve deeper into the judiciary's role and its interaction with the criminal justice system's key players in this video, tracking a criminal case's journey from the crime's occurrence. Police investigate and charge suspects. The police charge a suspect once they accumulate adequate evidence. Serious crimes like murder or kidnapping require consultation with the Director of Public Prosecutions before charging. Following this, the suspect is presented to a district court, initiating preliminary inquiries in the case of indictable offenses or summary trials for summary offenses. Magistrates, otherwise known as district court judges, hear these. Police responsibilities in this process include filing the case and handling courtroom affairs, such as maintaining order and escorting defendants, providing the court with the defendant's criminal history from the Criminal Records Office to aid in bail decisions, safeguarding and submitting evidence such as firearms, clothing to the Forensic Science Center for analysis. Scientists analyze and interpret. Evidence collected by the police, including firearms, narcotics, or documents, are analyzed at the Forensic Science Center in Federation Park. The center has divisions specializing in post-mortem examinations and various forensic disciplines, including a lab for DNA analysis. Services they provide include determining the firearm type used in a crime, identifying drugs or poisons in bodily fluids, counterfeit currency and stolen vehicles examination, seized drugs examination and analysis. Police rely on the center's written reports, which include expert findings and opinions for court evidence presentation, handled by another key player in the justice system, the DPP. Director of Public Prosecutions presents evidence. The Director of Public Prosecutions oversees all criminal prosecutions, with State Counsel presenting evidence against defendants. The police provide the case file, including all evidence. At the district courts, though, they are policemen who prosecute. Defendants can self-represent or opt for an attorney. If they can't afford one, the Legal Aid and Advisory Authority, or the Public Defender's Department may assist. Judges and judicial officers hear the case. The judiciary comprises 3 levels: district courts, the High Court, and the Court of Appeal. The Children Court handles cases with defendants under 18, offering child-specific support and sanctions to aid positive development and restoration. Criminal cases fall into 3 categories, dictating which court hears the case. Summary matters. Summary offenses such as theft, handled by the district courts. Indictable matters. Serious crimes such as murder start with a preliminary inquiry in district courts, which determines if the case proceeds to the High Court. Triable either way matters. These offenses can go to either the High Court or a district court based on the defendant's decision after the prosecution's recommendation. Summary proceedings. Court hearings at the district court. If a defendant pleads guilty, the district court judge will sentence them directly by passing the trial. However, if they plead not guilty, the matter goes to trial. Bail. A district court judge can grant bail for all cases except for murder. Only a High Court judge can decide on bail for murder. To help the court decide on any application for bail, the defendant argues that he is not a flight risk and will not harm anyone or commit an offense while on bail. The prosecution has to show that there is a real chance that the defendant might disappear or harm someone or commit an offense while on bail. In a summary trial, the procedure includes: the police prosecutor presents the state's case and the defense cross-examines the witnesses. The prosecution cross-examines defense witnesses. Post this, the district court judge evaluates the evidence and delivers a verdict. If guilty, the judge imposes a sentence which can vary from imprisonment to probation, community service, or rehabilitation programs. Defendants can appeal to the Court of Appeal if they disagree with the verdict. For preliminary inquiries for more serious crimes, the process is as follows. It's a hearing, not a trial. Evidence is either given orally or filed as witness statements. In both cases, the defense gets to cross-examine. The judge decides if there's enough evidence to move the case to the High Court. Defendants can either be discharged or committed for trial. If committed, the court must prepare and send all depositions and all relevant documents to the office of the DPP, who then must file an indictment at the Criminal High Court for proceedings to continue. Until the DPP files an indictment, nothing can happen. The case cannot go to trial in the High Court, and even if the defendant wants to plead guilty, he cannot. He must wait on the indictment to be filed. Case flow through the Criminal High Court. When a case goes to the Criminal High Court, it undergoes 4 main stages. 1. Assignment to a High Court judge. After the DPP files the indictment, a High Court judge is assigned the case, aided by a master of the High Court. The master also hears bail applications, except in murder cases. The court serves the indictment on the defendant. 2. Case management phase. The master guides the parties as per the criminal procedure rules to ensure a smooth progression. The master ensures that both sides submit and exchange the necessary documents, that parties have their witnesses available or agree on tendering their statements, and that the case is managed. Post this phase, a certificate of readiness is filed indicating the chosen trial mode, jury or judge alone. There are alternatives such as maximum sentence indication, MSI, or plea discussion and agreement, which the master can inquire about. 3. Pre-trial review. If the case is going to a full trial, the case is transferred to the judge, who conducts a pre-trial review. Here, applications from the prosecution or defense are heard and the trial date is set. Trial phase. The defendant pleads guilty or not guilty in an arraignment. The prosecution presents its case first, followed by the defense. The judge or jury decides a verdict. If the trial was by judge alone, the judge must explain the reasons for the verdict. A jury does not give reasons or explanation for their verdict. Appeals against a guilty verdict or an acquittal after the defendant submits that the prosecutor did not make out their case can be made to the Court of Appeal or the Privy Council with special permission. 4. Sentencing phase. If found guilty, the defendant may present mitigating facts to the court to try to shorten the sentence. Sentencing may be custodial or non-custodial, with several agencies aiding in the rehabilitation of the accused. Probation Services Department can help with non-custodial sentences. If mental capacity is an issue, an evaluation at the St. Anne's Psychiatric Hospital may be ordered. If sentenced to prison, the offender is placed under the care of the prison service. 5. For these steps, the court must rely on the parties or their lawyers to be present and ready to present their case. If there is no prosecutor, there is no case presented, and so the court cannot go on to hear the case. Without the defendant's lawyer, it is very difficult and sometimes impossible for the court to proceed. Jurors. Jurors are selected from a list of electors that is settled periodically. The judiciary sends out staff who are marshal's assistants to find the persons in order to serve hundreds of jury summons throughout the country each month. Those who are served can apply for exemptions, which are heard by a master. Those who remain can be placed to sit on a jury for a trial after surviving challenges by the parties. Role of the prison service. The prison service takes over once a defendant is committed for trial or a prisoner is serving a sentence. The court order is called a remand or a warrant of commitment. The collaboration with the judiciary continues because the court relies on the prison service to ensure the defendant's court attendance, maintain comprehensive, up-to-date inmate records, provide progress reports on inmates to the court. Conclusion: the judiciary is independent but does not work alone. It collaborates with many organizations which must pass the baton along smoothly in order to ensure that every participant in the criminal justice system enjoys the protection of the law.
Shri, thank you very much for that presentation. I'm sure that the public would have gleaned from that we have started from when a matter is first reported to the police up to the time of the appeal and the ending of the matter and all that is in between. It has shown exactly what the processes are and what is involved from commission, detection, trial, appeal, and disposition. So we'd want to acknowledge that a lot of thought went into this, and it was well thought out, and we wish to thank you for that presentation. Members of the public, you are invited to make your comments or any questions on the PAL website, and we will entertain what questions we can once time permits. I will now invite the Court Executive Administrator to give brief opening remarks, and I'm told that there's a brief presentation also.
Thank you very much, Chair. Chair, first of all, I would like to thank the committee on behalf of the judiciary for the opportunity to have this exchange. It is so important, we believe, that the arms of the state speak and that we speak appropriately. And I'd like to thank the committee for having designed this opportunity in this way so that our interaction could be appropriate. It is much appreciated.
You're very welcome. We try for reciprocity, and the improvement of the criminal justice system can only benefit the country and the citizenry as a whole, and we are grateful that you have attended, and we look forward to your opening presentation.
Thank you very much, Chair. Chair, I would like to ask Mr. Anderson Gordon, who is our Planning Director, to just take us through a brief presentation that hopefully would give an indication as to how the judiciary is thinking in terms of the criminal justice system and what the judiciary is doing. So I would like to pass over to Mr. Gordon, through you.
Of course. Go ahead, Mr. Gordon. Good afternoon.
Good afternoon again, Chair. Thank you. The judiciary thinks it is important to begin this discussion by defining the criminal justice system in terms of functions and agencies, and to reflect a little bit on what came before in the video. The criminal justice system is a complex interconnection of agencies geared to protect society by a range of functions, including the detection of crime, the prosecution of persons accused of crime, while ensuring due process for those who are accused, delivering good judgments as far as is possible, and prescribing appropriate sentences and consequences with a view to not only protecting society from convicted persons and deterring crime, but also to rehabilitating offenders and reducing recidivism. Some of the key agencies who participate in this complex function include the Trinidad and Tobago Police Service, as was mentioned, Forensic Science Center, the Law Association of Trinidad and Tobago, Director of Public Prosecutions, Legal Aid and Advisory Authority, Public Defender's Department, the Trinidad and Tobago Prison Service, and of course the Judiciary of Trinidad and Tobago, among others. And it is important at this point to identify that when we speak of the Judiciary of Trinidad and Tobago in the context of the criminal justice system, we are referring to the magistracy, that is the district courts responsible for summary matters involving adults, the criminal high court responsible for indictable matters involving adults, and the children court, which is also a high court responsible for criminal matters, both summary and indictable, involving children. Having established the scope of the criminal justice system, the judiciary acknowledges and recognizes a reality, and that is, we have a problem. The crime rate is too high, and matters take much longer than we would like to be completed. But how do we assess the performance of the criminal justice system? I would like to point out two indicators. They are not the only ones, but they are often spoken about in the public domain. Many tend to assess the criminal justice system by looking at two indicators. One, backlog at the courts, and two, the level of expediency, the time to complete matters. We sometimes say the time to dispose of matters. Sometimes we say the age of matters at the time of disposition. But if we are to improve performance, we think it is important to look at the whole process, to take a systems approach. And as was mentioned by you earlier, Chair, reminding us that we have started from crime, the actual time that a crime is committed, all the way to the end, we have given a high-level process map that begins with crimes being committed, crimes being detected or reported, crimes being investigated and charging taking place. And once the charging is done, then matters can be filed at the court, depending on the type of matter, whether it is a summary matter or an indictable matter, and whether it involves an adult or it involves children. That will determine which court, the district courts, the criminal high court, or the children court, for the matter to be filed. And then what happens next is that there are hearings and a move to adjudicate at the courts. And this will result either in matters being completed which is what we want to happen. And sometimes at the end of a given period, we find that the matters are still in progress. The matters are not yet completed for various reasons. And those matters we say are pending. And this is what some people loosely refer to as backlog. That is not exactly what backlog is, but for the time being, we can go with that understanding. The matters are completed. They are completed either in the form of the accused persons being found not guilty or being found guilty and given various types of sentences, or the matter can even be withdrawn or in some cases dismissed for various reasons, for example, for want of prosecution. If we may return, Chair, to what we are facing, having established the scope of the criminal justice system and having taken a high-level look at the processes involved, we remind ourselves that the Republic of Trinidad and Tobago is facing a high crime rate, a high domestic violence rate as well, which we recognize contributes to this high crime rate and therefore also needs to be addressed, larger than expected criminal caseload at the Children Court. When the Children Court was first established, it was established with research suggesting that a certain number of matters would have been filed, and it's more than we thought. A rate of completion of matters that is lower than desired, and this problem also needs to be addressed. As a result of the rate of completion being lower than desired, there are matters left in the pending caseload. There are matters in the backlog because they are not done. This is sometimes as a result of lengthy delays comprised of significant number of adjournments, and some research recently done by the Judiciary recognizes that a significant proportion of these adjournments are related to case parties and attorneys. What is the Judiciary doing to respond to this? Chair, one way of summarizing the Judiciary's strategy, at the risk of oversimplifying it, is by referring to three goals. One, to enhance service delivery. Two, to reduce delay. Three, to reduce backlog. And these we recognize require re-engineering, data-driven management, and collaboration. If I may, Chair, just for a brief moment, drill down for a bit into these three goals. Number one, the Judiciary has divisionalized itself. The Judiciary recognizes that civil cases are different from criminal cases, and different from family cases, and different from children cases or estate administration. And therefore, in order to handle effectively and efficiently these various case types, the Judiciary recognizes the need for different requirements, different legislation, different rules, different systems, different processes, different resources, different training for the human resources, and different management systems and tools. So, by divisionalization, the Judiciary can focus the right resources on the right case types with a view to enhanced service delivery. And this approach will also lend itself to reducing delay. The Judiciary has also worked on decluttering the magistracy. There has been a removal of matters that did not need magisterial intervention. For example, traffic matters. We recognize that more than 50% of the matters coming to the magistracy were dealing with traffic tickets. And by removing these matters, the court can spend more time addressing our criminal matters instead of dealing with these traffic tickets. There has also been an attempt to remove licensing, and more of this will come in the near future. Provisions were made for family matters at the magistracy and domestic violence matters to be removed. And this process has started, though it is not fully implemented. And the more we remove these types of matters from the magistracy, the more the courts can focus on the criminal matters, both the summary matters and, in this moment, the indictable matters. There has also been a reduction, Chair, in the number of districts in the magistracy to allow for the consolidation of resources and to avoid unnecessary duplication of resources. In the past, Chair, some magistrates' courts may have 2 or 3 or 4 courtrooms that would even lend itself for one courtroom focusing on criminal matters, perhaps another focusing on family and domestic violence matters and so on. But there are some courts with only one courtroom, and therefore all the various case types have to compete for the attention of the magistrate, and that lends itself to delay actually in the handling of criminal matters. By reducing the number of districts, we are now no longer pinned to having a matter heard in the precise district in which the offense was committed. A matter that is committed anywhere in the North District can now be heard at any magistrate's court in the North District. Our backlog reduction strategies, and just to be clear, by backlog reduction, we mean to reduce what already exists. We have created dockets so that each judge has a docket or a workload which he or she has to attend to and reduce. We are applying the profiling of dockets so that matters that can be easily or more easily disposed of can be more easily disposed of, and this can lend to a certain kind of prioritization. We have been creating early disposition opportunities, and I will share a little on that in a few moments, ensuring that cases are well managed, holding managed trials when we must. It is the philosophy of the judiciary, Chair, that the judiciary does not exist in order to hold trials, but to resolve disputes. And so these disputes can be resolved by trials only as a last resort, if necessary. To ensure a more ubiquitous use of tools, including case management information, research and data analytics, and e-tools, including e-filing. Our delay reduction strategies, which means we also want to maintain a current docket, include some of what I've shared before, Chair, including that there are dockets that make judges responsible for cases from the time of filing so that the court can control the pace of litigation and not the lawyer or the litigants. And this is extremely important. It is a fundamental principle. It is the sine qua non of case flow management. It is the essential ingredient that the court and not lawyers and not litigants must control the pace of the matters and the progression of matters. Early identification, and I will address this in an analogy in a few moments, and a move towards early disposition and even the incentivizing of early disposition is another very important strategy. Again, manage trials when trials are necessary, written judgments only when necessary and within time. Effective transcription systems. Chair, if I may use an analogy, what we are seeing on the nation's highway, an old picture albeit, gives a sense of what we perceive in the criminal justice system at the courts. We have a large quantity at the start. That's part of the problem. The judiciary is, however, never discouraging access to justice. So far from saying, do not bring your matters to the judiciary because we want fewer, that's not what we are saying at all. There are opportunities for improvement in this regard. For example, Chair, through an effort to reduce recidivism, through rehabilitation, it means we will have fewer repeat offenders, and therefore there will be fewer cases coming to the judiciary. Special lanes. Special lanes includes divisions. So we mentioned earlier that we have various divisions. We have been divisionalizing. And we even have a children court for dealing with children matters, as opposed to the criminal high court for the adult matters. But special lanes also include special criminal courts. The number of lanes, and this can refer to, for example, the number of judges. But it is not the first port of call simply to increase the number of judges without measure. The judge is, in fact, the most expensive component, as it were. And so it is not the judiciary's intention to simply increase the number of judges without proper calculation on what is required. Not everything must go to Port of Spain. From our analogy, if not everything goes to Port of Spain, then we can reduce the number of vehicles or the number of cases on the highway. And what does this represent in our analogy? It represents that not everything must go to trial. In fact, we have found that there are alternatives. There are early disposition methods, including persons who may plead guilty, the use of MSIs, maximum sentence indications, and the use of plea bargaining. This means we also have to use access to exits, off-ramps, to continue the analogy of not everything going to Port of Spain. And last in my analogy for this afternoon is the management of stops. We have seen that simply by removing traffic lights, vehicular traffic flows. And so the judiciary recognizes the importance of reducing unnecessary adjournments so that the matters can flow through the system. This is another perspective of what I have shared, Chair. So for 100% of the matters that were filed, perhaps 20% of these matters might exit the system via an off-ramp called no contest or pleading guilty. Another 25%, as an example, might exit the highway via an off-ramp known as plea bargaining. And as we keep reducing, we eventually get to full trial that is simply, for example, and it is the goal, 15% of the matters that are filed. And there are other trials possible, reduced trial, because the issues have been refined to 1 or 2 or 3 matters. And therefore the trial can be fair to all involved, yet only addressing the key issues and therefore taking less time. Thus the time to disposition of matters is reduced, the number of matters in the pending caseload reduced. In summary, Chair, the judiciary recognizes opportunities for improvement. Number one is the abolition of preliminary inquiries. And this is important because, as it were, an indictable matter is going to the magistrate's court, and then that same matter is coming up to the High Court, if I may oversimplify it in that way. Appropriate charging. Less time between committals and the filing of indictments for as long as we remain in the system of preliminary inquiries. An exploration of alternative options for early disposition. Greater adherence to the criminal proceedings rules. More training, exposure, and mentoring of young attorneys at the criminal bar. Continued docket management and the use of early identification and disposition strategies, as we identified in our reverse telescope on the previous slide. Greater readying for technology and greater use of technology among justice sector stakeholders. And this includes the use of video conferencing, litigation management, and e-filing. And Chair, this is not only the use of technology by the judiciary, but it is important that other justice sector partners also employ the use of appropriate technology. To give the analogy of the relay, as was mentioned before, it would really be counterproductive in winning the race against crime if one leg of the race is run very speedily and another leg, it's simply a walk. The judiciary also recognizes that in moving to the use of technology in a greater way, in a more ubiquitous way, some of its customers run the risk of their access to justice being restricted because they may not have access to the technology. And therefore, the judiciary has created virtual access customer centers, which we refer to as VACs, that are, if I may oversimplify it, booths that can be scheduled for use by customers, and they can come in and they can access the technology and attend court even though they are not physically at the specific court location in which the matter is being heard. Another opportunity for improvement is the continued rollout of the family court to address domestic violence. And this not only is going to reduce, to go back to the analogy, the traffic analogy, the number of vehicles, the number of matters at access the road at the start, but also to remove these domestic violence matters from the magistracy, so that they can be heard in a facility and by judicial officers who are more appropriately trained, and facilities that are more appropriately constructed for those types of matters, and also to increase the efficiency of the magistracy by allowing it to more easily deal with the criminal matters coming to the district courts. A greater emphasis on rehabilitation that we also mentioned assists in reducing crime. An enhanced and proactive public education. In short, Chair, the judiciary has been doing things, and other stakeholders have key things to do as well. But together, we can make a big difference. Thank you, Chair.
Judiciary, we want to thank you for that presentation. We want to move into the interrogation without any delay. Tell me, in improving the criminal justice system, was it considered that maybe a restorative justice approach can be appropriate? And when I say that, I mean the engaging of the offenders and victims in a way that may resolve the matter. In certain instances, there are some which it can't work, but the learning certainly provides for, and in other jurisdictions such as in New Zealand, the Maori, it's done in certain Southern African countries. Ubuntu, it is done there. It is done in certain states in the United States of America. Has the judiciary considered the implementation of restorative justice as a means of effectively improving the criminal justice system?
Thank you, Chair. The first thing is that, yes, it is something that's discussed all the time. We must, of course, remember that only the DPP can compromise a criminal matter. And so the involvement of the DPP in something like this is of critical import. You will find that the judges have at times been using, for example, victim impact statements and things of that nature. But in terms of charging, of course, the judiciary would not have a role. And then in terms of pre-trial, as I said, the DPP's role would be critical.
But, Madam Administrator, do you not think, and you are an experienced judicial officer of some vintage, do you not think the time has come to have a systematic introduction of restorative justice in the criminal justice system of Trinidad and Tobago? And I say that I bring to bear the New Zealand, the Mennonites. Why can't the wheel need not be invented? Does the judiciary have the appetite to introduce restorative justice as part of the process of improving the criminal justice system with all the stakeholders, of course?
And the answer to that would be yes, but taking into account, and we must take into account, that constitutional remit. So we have to be very careful when we speak about the extent to which we would like to go. We note, for example, that Jamaica has been able to do certain things. We keep a keen eye on those things. We interact as well with our colleagues in other jurisdictions. The New Zealand Department of Courts is an organization that we interact with. And the system that they have developed has been developed outside of the court system. And so therefore it's the Maori court system that has developed this, and that they have a series of quote-unquote indigenous courts. So the thing is that it would have to be structured in a particular way. Would the judiciary like to see more restorative justice? Oh, yes, we would, most definitely. The question, of course, and the devil is in the details.
Thank you. In your submissions, you stated that most of the agencies in the criminal justice system are, and I quote, shackled and inoculated against improvement and enhanced efficiency by public service-wide policies and systems that simply do not fit the task at hand. The submissions went on to state that oftentimes a law says something and a public service policy and procedure effectively and skillfully negates its intent and or its effect. This is a very serious statement that is a cause for legitimate concern. Can you elaborate a little so that we can interrogate this statement?
Yes, thank you, Chair. if I may start, for example, by dealing with our organizational structures. We have public service organizational structures that are designed for ministries. They do not suit a judiciary. They do not suit criminal law chambers, which is a chambers, not a purely a ministry. The systems have to be different. The processes have to be different. The very design and organization has to be different. Recruitment has to be different. All aspects of it must be different. And we have not given sufficient thought to a lot of this. What tends to happen is that within the public service, there is an attempt to make everything fit in to a ministry design. If I may give you an example of something, a very simple thing. As you know, the Registrar of the Supreme Court is the Marshal of Trinidad and Tobago. And the role of the Marshal is embedded in the common law. And the Marshal must take its instructions from the court. The role of the Marshal is to ensure that the court's orders are carried out. So, for example, one of the things about the common law and the Marshal is that the Marshal is paid for their out-of-pocket expenses as they do their business. Now, we have taken that and in trying to fit it in to public service as we know it, we have made the Marshal's assistants traveling officers. So there are a lot of public officers who are Marshal's assistants. They report to the Registrar and Marshal. Let us say, for example, we're sending out jury summonses. The Marshal's role is to go all over Trinidad and Tobago and find these people. So they are out there, they're on the roads, and they have to find the people. We have a system in the public service that says that a traveling officer can only travel X number of miles per month. And in order to travel more miles than that, they need a special permission. I recall on one occasion getting a query from the Auditor General's office because our Marshal's assistants were traveling far more than that. And when I pointed out, but this is by order of the court, the response was, well, no, the CPO has to approve it. So the thought that the court makes an order and the CPO has to approve the court's order, I think is not in keeping with the law or the rule of law. So that's a simple explanation, a simple example. But we see it in so many ways. We see, for example, the selection of people. And the fact that for the judiciary is staffed in the main by public servants who come from a centralized civil service. And that causes great problems. So we may get people coming in who really don't understand. They're coming in from a ministry, they're coming in from somewhere completely different, and we're putting them to draft court orders.
This dialectic, because I suspect it really is an interplay, because on the one hand you have that, On the other hand, you have the Judicial and Legal Service Commission, which is there to insulate judges from any interference and make sure that their independence remains sacrosanct. Could you then, may I suggest, and I've seen your proclivities for work, could you provide us with a succinct presentation that this committee can make a recommendation in this regard in order to straddle, because it's really a straddling, that issue of the public service and its non-sibling, non-finding of a sibling with the judiciary, particularly the criminal justice system, and I will tell you why. Once there is the will and there is the acumen, it can be done. Things have changed, we have evolved, we have morphed. And if we can get that, madam, we certainly will make it as part of our presentation in order to align the efficiency of the judiciary with that what exists in the public service. I will not go as far as saying that do you think it's time that the public service in this format we take another look at it. It may very well be that is the answer, but could you provide us with that in writing so that we can distill it and formulate it in a way and submit it to the Parliament of Trinidad and Tobago?
Yes, of course, Chair.
Thank you. I would now give way. It raises several other questions, but I want to give way to Member Paul Richards, who has some questions.
Thank you, Chair. Good afternoon again to members of the Judiciary, and may I place on the record and echo the sentiments of the Chairman of the deep appreciation and commendation. I think I speak for the other members of the committee for the leadership in the Judiciary making yourselves available for this exchange and this interface. It is not often. I think it's unprecedented.
It is unprecedented.
And particularly in the context of commendations for the opening presentation, very often there are misunderstandings about the function and role and structure of the judiciary in terms of its interplay with the other stakeholders and agencies in the criminal justice system, and of course delineating the role of the Family and Children's Court, criminal and civil courts, and magistracy, as Court Planner Director Gordon outlined in the presentation, and also the second part of the presentation, which clearly showed that the judiciary is not alien to the challenges facing Trinidad and Tobago. There's a clear understanding of the major challenges, and that they are being contemplated in the context of resolving some of those with suggestions. So my commendations to you on that. A lot to get through today, because we probably won't have this interface for a while again, although we hope to. In your submission, you identified, and also in the presentation, some critical flaws in the criminal justice system, including but not limited to over-incarceration, underutilization of plea bargaining, under-resourcing or inappropriate resourcing, the timeliness of delivery of justice, the fact that many of the processes are not, or decisions are not data-driven, a lack of trial certainty, the accused not being fully apprised of their options, the inability of police systems to keep up with the crime, unrealistic charging, too much focus on imprisonment, insufficient support, prevention, and restoration. And again, this is an interface not aimed at diminishing any agencies, but seeing how various agencies see the same problems in Trinidad and Tobago and how the agencies see the solutions moving forward. One of the submissions, and let me start with the inability of policing systems to keep up with crimes and unrealistic charging. One of your submissions under that header was, and I quote, "The country's approach to policing has not advanced as quickly as its crime. It has not been recognized in the police service and its organizational design that in modern policing, people who are called upon or even suited to walking the beat must be involved and play a critical role in crime fighting. Modern policing requires the best of the nation's human resource in various disciplines, including science, psychology, psychiatry, sociology, human behavior, technology, telecommunications, general packet radio service, medicine, among others, in the police service, and they must be paid accordingly. The country cannot continue to believe that all crime-fighting expertise must come from within the ranks and must have moved up through the ranks. Police systems which continue to be heavily manual with station diaries and other manual tools, and a belief that data entry is someone else's job as opposed to simply a different way of writing, hinder several processes. One of the practical examples you cited, an unfortunately low detection rate coupled with less than strong evidence gathering, which relies too little on scientific and objective evidence and too heavily on eyewitness testimony, hinders plea bargaining and guilty pleas. The fact that in the Tunapuna District Court, less than 1% of all indictable complaints determined in the 2021-2022 law term resulted from orders from committal to stand trial points to the need for stronger evidence gathering and or the need for more scientific evidence, end quote. That is a pretty hefty statement. And again, I want to stress this is not about bashing the police. This is about understanding your perspective on what comes to you. Mr. Gordon identified this is a relay. Usually the police intervene with alleged breaches, and it goes along the relay, passing the baton, eventually ending up in the hands of the judiciary. Could you elaborate on that in terms of what you see as the way forward? I'm sure that you have interfaces, though independent bodies, with the hierarchy of the police service in terms of resolving these issues for a more successful, transparent, and successful outcome.
Thank you. You know, a little while ago, the chair asked me about the public service and about the agencies having a difficult time in shedding or being free or able to shed public service cloaks. The police service is also a service. It is now part of the public service. It's a public service agency. And they too are constrained by public service modes, methods, etc. And it's just not suited. So in the same way in which it's not suited to the judiciary, and it's not suited to the largest law chambers in the country, it's also not suited to the police service. So the issue at hand is that, for example, let us look at that question of scientific evidence and plea bargaining. And it is something that was pointed out to me by the DPP initially. And I sat and I thought about it, and it is so true. And that is that when you're coming to negotiate a plea, and you are the DPP, and the evidence that you have is scientific evidence, then you're in a better position to negotiate an appropriate plea. If the evidence that you have is only eyewitness testimony, for want of a better term, sorry to use it, but I'll use it anyway, it's a bit of a poker game, you know. And so therefore, one of the things that an accused person would be thinking about, and his lawyer, would be hedging his bets. You're hedging your bets in all sorts of ways.
So then how significantly, and you spoke specifically about plea bargaining here, is this, and I'll use the phrase, quality of evidence, affecting the outcome of matters before the courts?
I think so.
How significant do you think that issue is?
I think it is extremely significant. Aside from the fact, of course, that we know that the Forensic Science Center has found themselves with quite a large, hefty backlog of lab work and ballistics work, etc., that they must do. And they're working on it. We know that because we all meet and we know they're working on it. But it's a significant backlog.
Well, the message that I read, I quoted from, sorry to interrupt, quoted several disciplines which suggest to me, and please correct me if I'm wrong, that the requisite expertise may not be residing in adequate quantities in the TTPS. Is that a correct assumption?
Yes, I think so. We definitely think so. We, when you look at it, yeah, DNA is being done, it's Forensic Science Center, yeah? They have a lot. When you're looking, for example, at modern policing, and we talk with modern police agencies in different parts of the world, you realize, for example, the importance of having and paying attention to psychologists, criminologists, the importance of well-trained scientists. These things are critical. There can't be an adjunct somewhere outside there. They have to be part and parcel of the entire investigatory apparatus.
From your conversations with the leadership of the police service, is it that some of the expertise is reposed, or is it that it's not there in the quantities that's required given the volume of criminal matters coming to the courts?
Well, my understanding is that there are certain bodies which are not within the public service or within the public sector. So, for example, we have some special units now, like the cybercrime unit, et cetera, et cetera. I cannot tell you whether they are sufficiently staffed. I cannot tell you whether they are staffed at the quality that they should be staffed, whether the terms and conditions attract the people who should be attracted. I can't answer that. I'm afraid that's not within my bailiwick.
One of the issues, and I'm sure one of my colleagues will get to it later on, is the issue of legislation. And to me, if what you are describing is accurate, and I have no reason to doubt you, even with the revision and the evolution of legislation, if the evidence coming before the courts does not meet a particular benchmark, is the legislation going to bear fruit?
No, it will not.
So the issue is police training and police expertise in this case.
This is a very important part of it. Well, not just training and expertise. It's also a question of design. It's organizational design.
Bear in mind that we are not, as Member Richard said, we are not bashing any organization. We are trying to interrogate here to find out how we can improve the criminal justice system. So we're not bashing the police. What we want to do is maybe have recommendations that they themselves, because they've been here before us, they've made their submissions. We understand there are constraints, but we understand there are some moves towards modernization. But what we want, we think that time is not our friend as it relates to crime.
I just have two more questions in this round before I pass on to one of my colleagues. In your submission, you also highlighted over-incarceration as one of the critical flaws within the criminal justice system. The committee is aware that certain legislation can potentially be used to address the issue of over-incarceration, including, but not limited to, plea bargaining, electronic monitoring, and amendments to the Bail Act, which have been passed in some measure and proclaimed. However, available data suggests the passage of legislation has not necessarily translated into reduction in the number of remanded inmates, which, according to submissions made to the committee by the National Security Ministry, accounts for approximately 66% of the prison population. Part one of the question: what challenges exist when attempts are made to apply legislation that would aid in the reduction of the number of remanded inmates? And two, have any discussions been held concerning the issue? If the answer is yes to part one of the question.
I will just put it to you this way. I know that there have been discussion of various types on the question, the issue at hand. I think as well that maybe the authorities had been led to believe that there were more people incarcerated on remand in particular categories than there actually were. So while there was some reduction, it was not as high as it really should have been, or it was anticipated that it would be. There are, and you've read out some of the possible considerations. Expanding the electronic monitoring system, for example, is one thing.
Expanding in what way? And I forgot to ask, define for us over-incarceration.
Over-incarceration comes about in many ways. It is just that there are too many people who are, quote unquote, inside. Whether they're inside on remand or inside as part of their sentence. With alternatives to custody, we can reduce the number of people who are inside as part of their sentence. And as we know as well, when they're inside, they're also learning. And what they're learning is not necessarily what you want them to learn. So sometimes we need more support services in order to support the entire area of rehabilitation.
Is it that the judiciary believes that the application of electronic monitoring as part of custodial sentencing, I presume, needs to be legislatively widened? Not meaning to draw you into...
No, I don't know that it needs to be legislatively widened. I think that you have a limited supply. You have, limited numbers, and so only so much can be done. But, it's a question, there's several more people, with all due respect, there's several more people who we incarcerate because there's no alternative to incarcerating them, because the structures and the support structures are not there to really take them out and deal with their rehabilitation properly.
My final question in this round is not meant to draw you into controversy, but to get a sense of where the judiciary stands on a debate that ensued pretty recently in terms of the amendment to the Bail Act, and with some persons on one side advocating, well, the Bail Act should have been extended in the way it was brought to Parliament, but it wasn't. And another position was that, well, it was not being applied, or quote-unquote judges were letting people go. And so the evidence to support the extension was not there. Would you care to comment on that in the context of that debate and the effectiveness or ineffectiveness of it before the sunset clause became active?
Nobody wants to hold that potato, madam. It's all right.
Is it too much?
If
I did have a proviso, I didn't want to draw you into controversy. But
nobody wants to hold that potato.
But it's a relevant conversation in the wider space.
We're not going to speak to the question of the Bail Act. We don't think it's appropriate for us to speak to the question of the Bail Act. There's something, though, that we would like to see.
Absolutely.
Because we have heard a lot about, since the decision, which has made it clear that one can be bailed for murder. I think it's somehow in the public domain that the judges have been opening the jail doors and allowing everyone on murder to walk out. And so I just wanted to give you some ideas or some figures. And if we could start, for example, we take this through from the month of May 2022 to May 2023. And in the first month, 27 matters were listed, 6 were granted. Second month, 87 were listed, 3 were granted. In the third month, 70 were listed, 4 were granted. In the next month, 67, 4 were granted. The next month, 65, 5 were granted. Then 38, of which 2 were granted. 46, of which 3 were granted. 53, of which 5 were granted. 58, of which none was granted. 54, of which 3 was granted. 61, of which 3 were granted. 46, of which 1 was granted. And 26, of which none was granted.
And just for clarity, these are matters that came and bail granted.
That's correct. Yes, murder, for murder.
Madam, thank you, Member Richards. Following up on that, though, because as an addendum to that judgment, there's a recent judgment that came out, I think, fortnight ago, and there is a dissenting judgment of Justice of Appeal Budu Singh, where, and this is important, and this is an important discourse in our criminal justice system, particularly the overcrowding and of the prisons. In that judgment, although dissenting, but the dissent was not on this part of it was not on the main issue, because the Court of Appeal decided on a preliminary point and didn't go further. But there are about 7 items listed there in that judgment that deals with the concept of bail now in a system where in murder, bail is now available. Monitoring, reporting to the police station, having certain aspects of assigned homes, having aspects of a curfew. Is there going to be a sensitization? Because the figures that you've quoted there for bail and murder, they're very grim for a defense attorney. Is there going to be some sensitization to these factors as it relates to bail for, and just not murder, but other offenses that may reduce persons in the prison population? And particularly, I don't know if the country got your comment about what is learned in prison. I suspect what you mean is you go in there on a softened matter, but you come out a hardened criminal, and that may very well lead to recidivism. I think that is what you meant. Is there going to be a sensitization? We are not at all wanting to impose on the absolute discretion of the sitting judge or magistrate to grant bail. But is there going to be a sensitization on the part of the judiciary for its officers as it relates to that approach to bail?
As you know, there's a JEITT, and one of the areas that's Judicial Education Institute of Trinidad and Tobago, which is part of the judiciary. And this is one of the areas that the JEITT is looking at. But I do want to point something out. And maybe this is something that the committee could look at. And I'll ask Andy to correct me if I'm wrong. Let us move from there. But I believe the electronic monitoring unit is of the view that the electronic monitoring system cannot be used for bail for murder. I haven't looked at it closely myself, but they have expressed the view that the legislation prohibits this. So I know, for example, that it has been something that the judges had wanted to look at. But the electronic monitoring system has a certain amount of collaboration in it. And the electronic monitoring unit has to do certain things and then report back to the court as to whether
Suitability.
they can.
Yes.
Right. And so in those circumstances, there have been those challenges, and they have actually declined. Yeah.
They have declined.
Yes.
We
Well, you know, they're based on the law.
they have declined. The member Lakshmi Diyal.
Thank you, Chair. Good afternoon, everyone, and thank you all so much for being here, but also thank you so much for the information. Your presentations were indeed very enlightening, and particularly the first one, the very animated one. I know it was done for us, but I would hope that it could be shared widely through whatever platform with the general public, because I think that there's a really fundamental misunderstanding amongst the public. When they hear criminal justice system, they think judiciary, and they do not understand the number of moving parts. And it would be great for them to be able to look at that video, and it's so aesthetically pleasing to look at. It might resonate well with members of the public. Thank you again for that breakdown about bail. Personally, I have a vested interest in that matter. What I would say as well, that perhaps it would be interesting to know on the number of matters granted, how many years those persons may have been on remand before being able to access bail, because that would as well speak to some of the issues that you yourself have identified, where persons are waiting for a very long time on remand and may actually be susceptible to becoming, you know, as the chairman said, hardened criminals. So I think that information is very helpful, and it would go a long way to easing and allaying the fears of the public that somehow all prison cells in remand yard have flung open and murderers have been, you know, let loose on the public by the judiciary, because that certainly has not been, as far as I'm aware, what is taking place. So I'm grateful for the confirmation of that. I have quite a bit of questions, but I'll try to limit them. The first thing, based on one of the presentations, the second presentation by Mr. Gordon, you spoke about the criminal proceedings rules. And of course, I guess everybody knows, but I'll declare I am a practitioner, so I've tried to bring a practical perspective to this. The lack of sanctions in the criminal proceedings rules compared to the civil proceedings rules, a lot of attorneys feel that it doesn't bear as much fruit as it can in terms of ensuring that we don't have delays. So some of those, to use your traffic analogy, some of the stops along the way aren't being managed well because there are no sanctions. And so we have delays taking place where it's discretionary. Whereas on the civil side, you miss deadlines, there are certain things you just simply cannot overcome when you fail to file witness statements and so on. Whereas in the criminal side, there's still a lot of discretion on the part of the judicial officer. And that is sometimes, from the private bar, a lot of people feel that that is contributing to a delay in the system because a lot of leeway is given to the state. I've actually been told many times by judicial officers that, well, we know what the situation is, meaning, quote unquote, the lack of resources, etc., for state prosecutors, the police. And, you know, do you feel that it's time for us to tighten up after a few years on the criminal proceedings rules and have sanctions in place for failures to meet deadlines and so on? Because that may be the only way to ensure that these stops along the route are managed better.
Thank you. First of all, when it comes to the study on adjournments, we've realized that it's over 65% of them are on the application or the behest of attorneys, sometimes prosecution, sometimes defense, sometimes both sides. With the finger being tipped and the scale being tipped slightly on the side of defense. One of the things, the way in which sanctions can play out in the civil system. As you know, it's a little more difficult in the criminal system. And there's also a victim who may just be left. So there's a lot to consider. I, however, think it unfortunate that we would have to be talking about sanctions with our colleagues and as part of the legal profession. I would like to think that we wouldn't need to look at sanctions to understand our role and the part that we have to play in this societal issue.
See, the issue comes back to a discussion that we had with other agencies coming here, particularly the TTPS, where still a large portion of the prosecutions are handled by TTPS. And we've heard from the management of the TTPS that they are, if something doesn't happen in terms of a court matter progressing, that they will take disciplinary action, that they will investigate, etc. But if sanctions aren't imposed, so for example, police officers missing court, prosecutors not complying with directions of the criminal court, particularly at the district court level and so on, if there are no sanctions, then the indiscipline, for want of a better word, by the prosecutorial authorities, particularly in the TTPS, isn't escalated. So there's no corrective action because there's no sanction. So we're sort of like just staying where we are because the court isn't imposing a sanction, and therefore there's nothing to report and nothing to escalate to the management of the TTPS. So then there's no corrective action. And that's why I think a lot of people feel that perhaps, maybe there's a different way, not sanctions, but maybe a way that the judiciary could then escalate the matter without having to impose. You're right, the victim is the one who may suffer if there's a sanction, and we don't want that for sure. I've been in a position where I've had to intervene in criminal prosecutions representing victims and threatening judicial review in order to get a substitute complainant assigned to a case. Why do we have to resort to that? I don't know, but because the court isn't throwing the matter out, because it was a sexual offense matter, the prosecution continuously came to court unprepared, saying that a complainant had retired, the file not being reassigned, and without a sanction, it was never escalated until a pre-action protocol letter threatening judicial review landed on the desk of the Commissioner of Police. So how can the judiciary assist with resolving these issues then without resorting to sanctions in the criminal proceedings rules?
The example that you gave really sort of begs the question as to then what are the standards by which the TTPS assessing their officers who are prosecuting, because you shouldn't have to wait on the court to sanction in a situation in which the record is there. An officer is going to court and is unprepared. There's adjournment after adjournment after adjournment at their behest, and the record is there. So, and it's not to say that these records are hidden. They're not hidden. A supervisor should know what's going on with your case, just as you would in your chambers or in your law firm.
I think, yeah, but as you noted, the TTPS that actually trapped in a public service structure that perhaps doesn't work for them. So whereas in the law chamber, if my docket showed that I was attending court over and over and not producing a result, I might, have a very strongly worded reprimand, and I would quickly, skip into action. I don't know that that's happening in the TTPS. So I say that just to say that the lack of sanctions perhaps is one reason why these things aren't being escalated. But if there's a way that it could be that the judiciary could, because as we've all acknowledged here today, if the TTPS, as the main prosecutorial body, and I think it was part of your presentation, that without a prosecutor, nothing can happen. And if without the main prosecutorial body really getting into shape, when they come before the judiciary, then your role is very, it's a serious impediment to you and to the criminal justice system being able to function properly. So I flag it just for that reason. Let me move on quickly. You mentioned one other thing about specialized courts. Recently, I was doing some research on the civil side, for example, into specialized commercial courts to deal with large-scale commercial type matters. And I've also found, and I think it was mentioned, that particular types of crimes do belong in a different type of setting. I believe that was the thinking behind the establishment of the family court. Sexual crimes, for example, I think specialized courts to deal with sexual offenses and to fast-track those matters simply because you cannot have a prosecution of a sexual offense crime without a virtual complainant in most cases. And it truly is heartbreaking when you see victims of sexual offenses having to relive experiences and give evidence 10 and 15 years after the commission of the offense. Is the judiciary considering, apart from the divisions which exist now, other types of specialized courts, and what are those courts that do you think is a specialized court for sexual offenses one of those things that is on the table and receiving consideration?
My apologies. I said yes, very much so. We're in the process of setting up sexual offenses and human trafficking court, a special criminal court for that purpose. We've noted that those figures are extremely high. The time to disposition is far too long. It means, of course, what it means for the victim. We haven't lost sight at all of what it means for the victim. And there are several things that are taking place in that arena. There's actually a committee that is working assiduously on it, headed or co-headed by Justice Waterman Latrue and myself. And so we're well on our way in that particular score. Just one thing my colleague pointed out here, because as we were speaking about adjournments, and that is that in the High Court study, the adjournments by the defense are more than twice the number of adjournments from the state. So,
yeah, that's where the police aren't prosecuting. That's
right.
The DPPs
Yeah.
I would say more with the police prosecutions, which is where the bulk of them, unfortunately,
that's correct.
take place. Yes.
And, there are issues.
Sure. And that actually would be a whole other discussion, because I think one of the issues affecting the criminal justice system, which I think has been somewhat alleviated now, though, is, well, at least back when I used to practice in the High Court criminal side, the absence of criminal defense attorneys and legal aid. But I think that's been somewhat alleviated now with the Public Defender's Department. That's correct. Let me wrap these two questions together. You would have mentioned that you want to move, that there's a move towards shifting the domestic violence matters into the family courts, and also the use of the virtual access centers. Now, I agree, family matters, because if you attend particularly the rural courts and you see what happens there before COVID, really, but you see what happens there even in a virtual environment now on a morning where you have a family list, and areas like, for example, Couva, where there's one court, it's chaos. So we have virtual chaos now as opposed to physical chaos, but it's still chaos. And you have, the shouting of names, and all of your business is just, it's truly inappropriate. So I do believe that family matters and anything involving children, anything involving domestic disputes ought to be moved. The problem is that particularly when you're dealing with rural areas, it's about access. And I will give you the example that in Point Fortin, in Separia, when you have a domestic situation that arises at 1 o'clock in the morning, and someone is at the police station, they are literally by 9 o'clock sometimes in front of the magistrate, which is 2 buildings down from the police station. When you are dealing with persons who are restricted in terms of their access to resources, in terms of support systems, in terms of simply being able to physically find themselves to San Fernando or Port of Spain, or in this case now we have the Children's Court in Faizabad, you know, the rural courts, the district courts are their first stop. From the minute you interact with a person who, and again, we have to take into account persons from all walks of life. You're dealing with someone who leaves the rural area in which they live 2 or 3 times for the year to venture into Port of Spain. You tell them that their matter will now be heard in San Fernando, in Port of Spain, and they must leave Palo Seco or Santa Flora. Not that I'm saying that these places are, you know, people don't have access. I'm just giving you the example. You pose a challenge. So have you thought about how to balance that, because this is about access to justice as well. Physical access to a courtroom is part of access to justice, and physically being able to present yourself quickly and expeditiously, particularly in these types of matters, in front of a magistrate to get relief. How do you balance that against the, you know, the need to remove it from the district courts and have a more suitable environment for it? And tied to that, how many virtual access centers are currently up and running and operational, and how many do you intend, are there plans to have more, and how many do you intend to have?
The districtization of the courts, where we have 3 districts, which is Tobago, North and South, what that gives is really better access to the courts, because you have a multi-door sort of approach. So for example, you can, even though it's a domestic violence matter, and say we had a family court, you can access the closest court next to you, because in the north, you have everything from Chagonas and then up the corridor, and then from the south, for the south, you have from Couva all the way back. So you can really go to any district court with districtization.
Right. In terms of moving the matters out of the district courts that relate to domestic violence and moving them to a family court, are you then saying that somebody in Beach who goes to the Beach police station to apply for protection would then have their matter heard in the well, there's no family court in San Fernando yet.
There's a VAC, I think maybe you don't have, there's a VAC system in every court. So therefore, you can go to any court to access the family court. You can go to a VAC at any court to access the family court. And then too, there's also the domestic violence hotline. So the judiciary has set up a domestic violence hotline, which is heavily used. We would like to go back, be able to extend it again to 24/7, but we do not have the resources so to do. But the point of the matter is that it is very heavily used. And because a matter is in the family court doesn't mean you have to physically go to the family court. And one of the things that a lot of domestic violence victims have actually been telling us is that they like the fact that they don't have to come to the court because they don't have to be in the same physical space with the perpetrator. So they feel more secure in one of our VACs, and it makes access to justice much easier.
So the intention would be then that if you move family matters out of district courts and place it in the family court, that the VACs at each district court would still be utilized to hear the matters through the family court.
VACs.
So then they could still go to the magistrate's courts.
Yes, they're VACs, yes. What happens, if I can explain how, but it's not a courtroom you're going to now. You see, if you think of a court as only courtrooms, then that's when you have the challenge in understanding it. So it's a question of, let me just take a pin. With districtization, what we have done is that we have centralized certain resources. So prior to this, we had 14 locations, 14 districts, and we had to repeat in each and every district the same resources, whether or not that particular district had any kind of caseload or any kind of volume for that particular type of thing. So what we have done is that we have pulled it together. We have studied what types of cases we see where, what types of volumes of what do we see where. And we have centralized some resources. We have identified locations in North, identified locations in South Trinidad, and determined that at this location, we will have almost a full run, a fully resourced organization. We look at some places and we say, okay, so for example, like Mearo, we will run that as a virtual access customer center. And so that is what Mearo has become. There are now 25 VACs, apparently, it's 25 VACs in the country. And you can go to a VACs for any access, right? High court, district court, for any access. The only VACs that, well, those are the VACs outside of prisons. Of course, we have the prison VACs as well. And those, of course, are for a particular purpose. But outside of that, there are 25 VACs.
At the district courts?
Oh, 25 VACs. Some of them are in individual buildings.
That's what I was going to ask. Yeah.
So
for the
25
where
VACs in different places.
Right. So what are some of the...
And with 25 more...
I want to...
Sorry, yes.
And with 25 more being done.
Okay, and what, could you give an example of some of the locations outside of the district courts where VACs would be located?
As I said, first, every court building.
Okay.
Right, you have a VAC.
Court buildings.
St. Vincent Street and Duke Street.
UTT.
Yes.
Okay,
O'Meara has
so the different VACs.
Yes.
Sure.
Yeah.
And in Tobago as well.
Right. So remember, Reps Roy, we are coming to you now. We will.
I'll give way in the next round.
Now, Madam, before I come to you, member, you have stated, as it relates to staffing, that the judiciary is still staffed by the public service system. Is the judiciary consulted before appointments are made relative to staff of the judiciary, acting or permanent?
No.
You agree that staffing at the judiciary may be exposed to certain files, certain documents, certain things. I want to say the word things. In improving the criminal justice system, so for example, in sexual offenses matters, those trials are done in camera. There's a reason for that, to protect the identity of the victim, to also protect the identity of the offender, because there's a presumption of innocence. We know what happens after there's a conviction. There's now the sexual offenders list, etc. Don't you think that as it relates to particularly sensitive staff, that the judiciary ought to be involved, at least, in the selection of those persons, particularly as it relates to sensitive matters that may arise in the criminal justice system?
Yes, Chair. As a matter of fact, we have the view that the judiciary, either the judiciary itself or the judiciary, maybe through an expanded JLSC, should be recruiting the staff for the judiciary.
You may find some help if you look at the Constitution, Section 1, 20, subsection 1(8), as it relates to the auditor and the ombudsman. It says, before the Public Service Commission makes any appointment to or transfers a member of staff of the Auditor General or Ombudsman, it shall first consult with the Auditor General or Ombudsman, as the case may be. This is a piece of legislation that exists for two offices, and I suspect the rationale for that is because there are sensitive areas when you go to the Ombudsman, or if there are sensitive issues that are raised there, the Auditor General even more sensitive. Doesn't the same rationale apply to the judiciary?
I would have thought so.
Member Webster Roy, you go right ahead, madam.
Thank you, Mr. Chairman. Before I get into the questions I have prepared for you, I just wanted to get the Tobago context. You mentioning VACs across Trinidad. I remember growing up in Roxborough and having a magistrate's court there, and then in Charlottesville, we don't have them anymore. So what provisions are in place for persons in rural communities in Tobago? Do they have to go to Scarborough for everything?
As a matter of fact, we have sought to have Roxborough. As you know, the building in Roxborough is now quite derelict. We have had the entire building checked, reviewed, and we have put forward a plan to the THA to deal with the refurbishment of that building for the holding of a VAC. Where we have VACs now at our different court buildings. We have noted the question of Charlottesville. We were no longer holding court in Charlottesville, and therefore it was thought best to give up the court building because we really were not using it. It was an out court. But what we always have to look at is the number of matters from a particular area. So therefore, we have decided to focus on Roxborough. And what we've actually decided we want to put down is, so it's a little more than a plain VAC, but other services as well. Because what we have as well in our court buildings, we also have kiosks. So aside from the VACs and the interchange and the way to deal with court, in our court buildings, we also have kiosk systems. So if someone wants to come, a litigant in person wants to file a matter, they must file electronically. So they can come to our kiosk, they can get assistance from one of our customer service staff, and they use our kiosk. We're also going to be doing a lot more with our kiosk quite soon because we are involved in a project for self-represented litigants that we call the SAFE project. And so those kiosks, we're going to be building what can be done from and out of those kiosks.
And how many kiosks we currently have in Tobago and the locations? It's just
the three.
The three. Okay. Before I go on to my other set of questions, I just want to commend you all for your presentation, especially the animated one. I want to make a plug for a child-friendly version want to be developed, focusing on the family and children court, so we could share it throughout the child care and protection sector, please. Right, thank you. In your submission, it was noted in a statement that certain basic policies that appear that have nothing to do with crime can invite or assist crime. Can you elaborate on that, please?
The context within, the context within which it is stated.
Because when I read it, I was really curious and I wanted to just understand,
What page are you referring to? So you look at it in context.
Try read your submissions of the 15th of May, 20. No, check a page 6. Check there. We've quoted it. I will try to find the, let me see it, please. Let me locate it directly in the submissions. Look at page, which one is it here? You found it?
Okay, Master Morris Allen, while we look for that, so you can get the context explained, I just want to ask another question. You found it?
Is it page 24?
Right.
21?
If I may.
Yes, you can. Well, it is a submission, so if you can speak to it, and when you find, you can get context.
Yes, thank you very much. It is on page 21. It speaks to what is needed policy-wise.
21 under the rubric 4B?
Yes. That's correct. Give you a couple of examples. Let's look, for example, at something like our transportation systems and our policies in terms of national transportation, at least to the extent to which they have been not implemented. And it is just that, for example, that whole question, as they say in transport, of the last mile, and how we handle the last mile. And that last mile invites a lot of crime. So there are policies throughout our system. When we stop and think about it, they actually invite crime. There are policies that cause our people to seek to circumvent things, and by that invite crime. Sometimes we call it, sometimes we refer to it as business opportunities.
You're not saying that crime is a business, presents a business opportunity.
If I may, Chair. There is legal and legitimate business, and there's illegitimate business.
Understood. Member Webster Roy?
If delay, for example, delay invites illegitimate business.
Member Webster Roy, before you go on that note, I've looked at your submission, and you said that you noted that the San Fernando has a higher rate of success in the progression of matters to indictment arising out of status hearing than Port of Spain. Could you tell us before, what is the rationale for that? What has this study revealed? No. The Port of Spain part really.
What I would say is that I suppose it's more somewhat of the internal process of the department responsible for filing of the indictments, that in San Fernando, the deputy director is usually allowed to review the matters and sign the indictment in San Fernando, so that because the matters are not going directly, all of the matters are not going directly to the director himself, and it's being dealt with in San Fernando by the deputy director, those are dealt with a bit faster, as there are perhaps less matters there as well.
Member Webster Roy, continue, please.
Thank you, Mr. Chairman. I want to turn to the children court, right? It was noted in the presentation, there was a larger than expected caseload in the children court. Based on the matters heard, what are some of the factors contributing to more children coming into conflict with the law? And has the peer mediation program assisted in any way in reducing recidivism among children who would have been in conflict with the law?
The court opened in February 2018, and to date, as at the end of April, we've had 4,500 and something matters filed at the children court. There are varying types of matters, of course, but we have, I think in terms of indictable matters, we have over 1,200, and summary we have almost 800. And then, of course, you have children in need of supervision, children's authority matters, etc. So we've had a large volume, and that gives us a sense of where we are as a society and the problems that we do have. And really the need for the court, because we really have to deal with children in a different way. For peer resolution, of course, matters only go to peer resolution when they're minor offenses. But the court really also tries to look at other non-custodial sentences for children who are in conflict with the law. And so it's very important to note that this court is really quite different. It's a problem-solving court, and that means that we really want to find out why this child is before the court. What has caused this child to be before the court? That child does not get there on their own. So what are the issues in their home, their environment, what's happening at school, etc., that would cause that child to be before the court? And that information is provided to the judge or the judicial officer so that the judge or judicial officer could really determine what are the targeted interventions we could make into this child's life, apart from dealing with the offense itself. And that is really critical, because I think you would agree that 4,500 and something matters. That's very high. And I think one of the things that's important as well, that the court considers as a court in establishing the court, we really looked at studies that spoke about the development of the child in general and how the brain develops. And, at a particular point in your life, in your development, you're making a lot of stupid mistakes. And so that is a consideration, because I don't think any of us in this room could say that we've never made a stupid mistake or stupid mistakes. And so that is something that the court looks at, and the situation surrounding this child. Because sometimes you find that adults have failed to parent a child or care for a child. So a child may end up before the court because they're really in need of care and protection. So, but the volume is high.
Thank you very much. What do you think are some of the systemic and institutional deficiencies that impact the effective administration of justice for matters pertaining to children?
I think we have to really look at early interventions. So, for example, from the time they hit primary school, what's happening at the secondary schools, that we can see that we have a lot going on in the secondary schools, and try to address why is there so much conflict? Why are these children engaging in certain behaviors? So we have to really catch it from early. We have to steer them away from the criminal justice system. But to do that, we have to invest the time and the money dealing with children at an early age. We also find that there are psycho-ed issues, there are mental health issues, and we have to address those issues. And I don't think a lot of resources are put into those issues, addressing those issues.
Master Morris Allen, in terms of the institutional relationship between the judiciary and the Children's Authority of Trinidad and Tobago, what are some of the recommendations you make to improve that relationship?
It's not been going as well as it should be. And I think it is because the Children's Authority found itself inundated. And in an effort to not sink under the sheer weight of the volume, they have sort of pulled back on the nature and extent of their interventions. I have said, and I'll be very frank on this, I have said that that is not the answer. To my mind, the authority needs to do what the authority was set up to do, and the resources need to be provided. What we're seeing, for example, is that there are orders made by the court that the authority is not obeying. And they may come back to court and say, well, you know, you told us to place this child in such and such, but we didn't have a place to put the child. Or, you know, you told us that the child should not be remaining with this person, but the child is still there because, you know, we didn't have a place to put the child. That, I know, is hard for them, but the point of the matter is that the court is pressing, and that is not the answer. The answer really is that we have to recognize and lobby for and find ways, because the authority was made an independent authority by law, and has to find ways of finding the resources that are necessary. You know, it took a lot historically by all sorts of bodies and agencies and countries to have us where we are in terms of certain areas of social difficulty. And we really can't, as a country, sit back and say, okay, well, now the NGOs and the FBOs have to fix it. We really need a serious, collaborative effort for the well-being of our children. Because we're seeing what's happening, and a child today not properly dealt with and not understood, and whose problems are not addressed, is going to be someone tomorrow who is going to be a lifelong criminal. And what are we going to do? Are we just going to lock up everybody? We can't do that as a nation. The point of the matter is, as a nation, when we look at our children, we are seeing that our children don't have the tools to handle conflict. We're seeing that our children are angry. The levels of anger among our children is shocking. And we need to look at that. And we need to look as well at the whole question of what tools are we going to give them to deal with their conflict and all of the other issues, including their raging hormones. What tools are we going to give them? And we have to invest in giving them those tools.
Maurice Allen, do you think the judiciary being integrated into the Standing Committee on Child Protection would foster that level of collaboration and coordination that you said is required to improve the circumstances of children, especially for children who come into conflict with the law?
No.
No? Okay.
I don't think that it is. I don't think that it's sufficient. Unfortunately, I'm speaking for myself here, not my colleagues, including Ms. Cross, who's on the committee. The problem is so large that, unfortunately, everybody's just seeing how best they could handle a piece of their part of the problem. It really needs a coordinated approach, and it needs a strong national investment. And that's not just a money investment. That's an investment in understanding children. It's an investment on a discourse on children, a national discourse on how we're raising our children. That is so important. We haven't had that national discourse. What's appropriate? What's inappropriate in parenting? A society should be looking askew at someone who is parenting wrongly. And in order for it to do that, we must have an idea of what is our national standard, what's done and what isn't done. And then we can talk to it. To quote King Austin too, we have children making children to be a part of this growing mass. And what they have been given to allow them to be parents. We can't speak about the criminal justice system without speaking about children. This is really, where we have to start and speak.
As you have said that, you would know, as someone who practiced in the courts, and Member Sukai, I'm coming to you directly after. The Mohammed and Taylor at 11 West End reports had an age for a young offender. Apparently, the age for young offenders from Mohammed and Taylor I think that was 1967. If you look at Regina and Howells, which is 1999, the age for young offenders is reducing. Is that a phenomenon that you have seen in the criminal justice system from the judiciary?
Yes.
I would ask the judiciary to tell us, the committee, what recommendations, because at the end of the day, some end up there as juveniles, yes? And what we don't want is the graduation from juveniles to adult offenders. We will take that response, the full response, in writing. But could you give us a response within a minute or two as it relates to that? We'll take the plenary response in writing. But give us that response within a minute, because I want to go to Member Sukai, and I would like to give all other members another one question, another rounds, because I know we have a 5:30 cutoff. We can go until 7, but could you tell us, please?
We need to be real and not just pick up things that are said in other countries or other jurisdictions. I know that there are many who are of the view, for example, that the age of criminal responsibility should be raised. And the judiciary had taken a view in the setting up of the children court that that age should not be raised. What is important is that the children are brought to the court, and what is important is what we do with them when we bring them. Because if we make the mistake of raising it, and so therefore we don't ever get to see them before they hit 14, it's already too late. And that's why the children court is set up, the way in which it is set up. People need to stop thinking of the concept of a court. Oh, if you take them to court, you know, it's a big criminal thing, etc. No, the court is designed in a particular way. And so I think this is one of the things that one of the key things that we have to recognize. Half a second more, if I may, with your leave.
Go ahead, madam, go ahead.
We have seen a lot of violence happening in schools.
Yes, we have.
And we need, the court and the Ministry of Education need more discussion. There's actually a document that was the protocols between we had the multi-agency protocols, but we also had an interagency protocol between police and education. And I do not think that the people who are there now in the schools are aware of it, or the people who are in police are aware of it. It's extremely important that that is understood. There are also things as well where education is concerned, where in the law we have actually included a responsibility for anyone who knows of a child being abused, etc. Anyone has a legal responsibility to report it. But the way in which Ministry of Education's policies are set up, the teachers tell us that they can't report it. It has to come through the principal and through the ministry. But the law says anyone.
Anyone.
Even some social workers, the social workers in the schools are telling us that they are not supposed to report it directly either. So these are systems that we need to look at. I don't know if it is so, if it is true, but this is what they're saying to us.
It cannot be true, because at the end of the day, the rationale is to have it reported. Who reports it does not negate the report. The essence is get the report to have an early intervention, and maybe I don't want, Member Sukai, I want you to start because time is going, but I will come back to this issue because I do have a question that flows from there, but I would want Member Sukai to have his say. Welcome.
Chair, thank you very much. And Chair, through you, Marcelin and your team from the Judiciary, and thank you for taking the time. And actually, you came with such a massive team today. You know, we could not enjoy the opportunity because we understand what's going on in Trinidad and Tobago. Likewise, just to add to the conversation, I believe that this issue we are having with children, and I'm happy to hear that you have a sort of clause by law where abuse cases, especially for these young individuals, could be brought forward. But I think that should be expanded, because while we have these platforms, these social media platforms, from YouTube to Instagram to everything, where we have adults and people who are considered leaders in our society spewing sort of venom out there, the younger ones are looking, because there's no way to be able to filter that, and that's how they are then molded. So I think somehow that abuse should be spread across the board, and that's just in my humble view. However, from your presentation, I want to thank Mr. Gordon as Minister in the Ministry of Works, and also my line minister, Mr. Rohanson. And I would like to know if you got approval from traffic management to create that rule. Being that and seeing that it adds to transportation, I want to find out something, because I know you spend a lot of time in terms of making the system more efficient in terms of costs, in terms of expediting the cases through. Given the high cost of appointing an attached judge, to certain cases, and you identify that you look at prioritizing the cases accordingly. However, you did state licensing, for removal of licensing, you're having an issue. Could you just explain that for a bit more? Because I would like to understand what is he thinking there, because there are a lot of cases when it comes to road offense or traffic offenses, and it'll be interesting to know what issue the judiciary has and how we can bring it from the ministry to assist.
Sorry, Vice Chair. When we talk about licensing there, we're talking about all of those licenses, like liquor licenses and all of those. Those are all done still in the, they were supposed to have been moved from the district court, but they are still with us, and it's far more complex. I will actually ask my colleague, Jamie, you want to speak to it? I will ask my colleague, Jamie Filbert, who handles civil and therefore handles that, to speak to.
I will start by just speaking generally in terms of the legislation that applies to licensing. There are various types of legislative enactments out there and provisions. So starting with the Liquor Licenses Act, as well as money lenders, etc. But there's no one piece of legislation that actually treats with licensing in terms of the structure, in terms of possibly the authority for procedure to be developed amongst the licensing committees and their members, etc. So that is one of the main challenges. You do have to access multiple pieces of legislation. Some of the legislation as well is respectfully a bit outdated in terms of looking at the current issues that we tend to treat with licensing. A lot of the committee members have also expressed concerns as well in terms of the development of the cases, and not just simple applications that come to the committees. And the committees generally are comprised of magistracy registrars who sit as chairpersons of the committees. They're also comprised of senior officers within the district courts who tend to be district clerks of the peace. They tend to be very senior persons within our court officers who, again, have other responsibilities within the court offices as well. We also pull from staff as well to provide secretarial support. And then members as well are nominated and appointed based on their positions within municipal corporations and the business community. But going back to apart from the composition of the committees, there's a lot of complexity within the cases, etc., because some of the applications are not necessarily straightforward. They require the members to sit and apply and look at areas of law and look at interpretation of legislation. Again, based on what I've described in terms of the composition of the committee, the most senior person who's the chairperson is also an attorney at law, and that really is just the only attorney on the committees. Depending on other issues that arise, including issues concerning environmental management, areas of economics, accounting, etc., there's usually no one on the committee who has the expertise, etc., to treat with those things. So again, it would help to revisit how the legislation is set up and the procedure. There are other concerns as well in terms of reports and the receipt of reports by the committees. Now, the committees don't operate in a vacuum. In order for the committees to make decisions, they require input as well from key stakeholders, including the TTPS, customs, fire services. That means, of course, the TTPS periodically visiting premises, determining whether the premises are suitable from a point of, the inspections, etc. Also the same with fire, health, etc. There are considerable delays the licensing committees experience generally in receiving timely reports from some of these agencies. And of course, these agencies are outside of the control of the licensing committees. So there's no real way to compel them to provide those reports in a timely manner. Right? So there are several other issues that arise within the context of the licensing committees at the moment. And so I can speak a bit more on those, but those I just highlighted the main issues. Generally, I think some of the solutions would be, again, the legislative review, looking at the legislation that currently exists within the context of what is required for licensing at the moment, and of course, having a bit more, I suppose, participation, deliberate participation and accountability from the various stakeholders to ensure that in terms of handling of applications, they're done in a timely manner.
You're absolutely right, because you're given sometimes where certain bar owners or even these party goers, they seek licensing and they disrupt the general well-being of the public due to noise creation and whatnot. So it's quite interesting that you say that, and maybe it's time to start the conversation for legislative reform and how we look at dispatching the licensing. And bringing back that into context, I want to find out, and thank you again for that response. I just want to find out, given that we have, in terms of forensic, the backlog within the Forensic Science Center, and also the way that we gather evidence, could this committee state, or I don't know if it was stated before, whether or not how many cases are thrown out from the courts because of supporting evidence inappropriately handled, or they're over time they've become null and void? Could this committee state, like, do you have a percentage, a number on that?
No, unfortunately, we don't. We don't drill down that deep in terms of manner of disposition. That would have to be a particular study that we would need to look at.
Madam Master, do you see that being an important piece of data to gather, given that forensic gathering is, one, it takes time, two, sometimes the gathering is not appropriately done by the party that's doing the evidence gathering, and also the storage and the method it's done, right? And then when brought before the courts, it's then thrown out. So do you think that is something, because I think a conversation needs to be open on that?
It's something we'd have to look at, because it would not be immediately evident from the manner of disposition, and so therefore a study like that would be more labor intensive, let me put it that way. So there are some studies that we would really love to do, but they are more labor intensive. So, and we don't have the resources to follow up on certain things like that. But I hear you.
Thank you again. And Chair, before my last question in this round, to assist the Forensic Science Center in the backlog with legislative and amendments, assist, for example, if the accused decides to contest, instead of having the firearm tested or the narcotics tested, they be charged for possession, or that, in other words, you're not looking at the item itself or the narcotics, then you're looking at possession. Could that be a solution?
We'd still have to be determining possession of what? What is the thing? And the only way the court knows that that thing is a firearm is not because the court looks at it. It's because the report says that it is. The same with a narcotic. The only way that you know that that powder or those crystals are cocaine is because of the test and the experts' evidence. So those types of things are challenges, but that's also why it's so important that forensic science center is able to move more quickly. Also, of course, when it comes to the question of, when it also comes to the question of, okay, you have a room full of cocaine. How much of it are you going to test? And are you going to test every package? There was a point in time at which forensics was testing every package. And, the suggestion was that, well, no, you could do samplings, and once you've crossed the amount to make it trafficking, you can say, okay, well, this is enough for trafficking, and maybe, you spot check after that. And there were two schools of thought on that. But I think we've gone more towards that direction just by sheer volume of work that they have to deal with.
So Trinidad and Tobago being we are known as a transshipment point for narcotics and illegal substance, right? I mean, there are many, the TTPS, can they play a more active role then in terms of curbing the backlog to forensic science, in terms of doing their quick check, like, internationally you have the Marquis test or the Wagner test when it comes to these narcotics. Is there, while there are pros and cons or certain inefficiencies that may arise in these tests when it comes to doing these quick tests, but can it help in some way whatsoever in filtering the cases through?
But, there's certain things, for example, certain processes that we've looked at. And, there's this whole process of something, the case coming first to the magistrate, and then the magistrate directing that it be sent to forensics. Whereas it can go to forensics first, and so then the report can come. But then there's also an opportunity, if we are all working together, and you have a judge's docket. And so if we're all working together and we know when cases are coming up, then forensics would also know that in these matters, we need the test done for these matters. Instead of them just going on and they have those tests done, but not these that are coming up in
So
court.
is that communication being
So
done?
you need that. But you see, unfortunately, that level of communication isn't there as yet. And why it's not there is because of exactly one of the things that Mr. Gordon raised, which was the importance of collaboration. The judiciary has set a system of docket management. If prosecutors are not assigned and scheduled in the same way or to meet this docket system, then there can't be the kind of planning that you need to have. So one of the challenges that the judiciary finds is that with the way in which prosecutors in the High Court, for example, are assigned, that at the end of a month, you have a completely different prosecutor working with you. So it affects case flow management. So one of the things that we would like to do is to have that kind of collaboration and assignment systems that meet
So what
our
is stopping
assignment
you?
systems.
What is stopping you? Sorry, Chair. What is stopping you from doing something like that?
Each agency has to organize what it does. And so police also have to organize what it does, right? We can't tell them what to do.
Madam the Administrator, the answer to sending the item to forensics before it comes before the magistrate, it may create a challenge unless legislation is changed, because there's something called the chain of custody. And before any item is brought for a trial, there must be some record that this was the item that was identified. These are the markings that was placed on it, and it was then sent. So maybe it leads me directly into the question that I have been asking, and the public has tried also in some form or fashion to cull this question. Do you think that more effective channels of communication should exist between the judiciary, the legislature, and the executive as it relates now to the challenge of fixing the criminal justice system? Now, we understand the concept of separation of powers, but there seems to be, to my mind, a certain territorial approach that precludes these different branches of the state from working effectively together in order to ameliorate, in order to improve the criminal justice system. What is the view of the judiciary in this regard? We understand the concept of separation of powers, but we have something that has been identified now as a health challenge, which is crime. Tell us.
Well, actually, I endorse what you said in terms of there needing to be appropriate discourse. One of the things, for example, is that following on what is done in other jurisdictions as well, too, it's one of the reasons that we have court administration, because court administration speaks for the judiciary, but it is able to interact with and interact easily with the other arms of the state. So some would say that court administration provides the appropriate buffer. That is the term that tends to be used. I also, though, think that what is very unfortunate sometimes is that there's a lack of understanding. We know from the judiciary's perspective that the other arms of the state and the public don't necessarily understand what we do, why we do it, and why we do what we do, how we do it. And it's always very difficult for a judiciary because we have been raised with the tenet that the judiciary does not speak. With court administration, you're able to start to come out of that somewhat. But not everyone is comfortable with it. And so to some extent, we know we have to hasten slowly. You would think that after, 25 years of court administration, it's the slowly part has really passed. But the point of the matter is that it is very difficult to move people and organizations from that general position. We would like to have better interactions with the other arms of the state. We would. The question, as I said, the devil is in the details. How do we do it? How do we do it and ensure that in a society that is very cynical, it is understood that we are not talking because somebody is telling us to fix the case, you know? Unfortunately, in this society that just jumps to that kind of nonsensical kind of conclusion all the time, it's what we see. But we even see it, if I may, we even see it as attorneys at the bar. When one attorney talks to the attorney on the other side, you know, there's the challenge talking to the lawyer on the other side, because somehow they're supposed to be fighting, you know, and so going there to sell out the case. And so it's a thinking that we need to address. So it doesn't just reside with the three arms of the state. It resides with the media and the whole Fifth Estate. It resides with the population's understanding and acceptance and way of thinking. So we have to get there.
But, Madam, you see, whilst we are getting there, there's an element out there that is getting ahead of itself and getting ahead of the country. I think that there are enough right-thinking people in Trinidad and Tobago to understand and appreciate where we have reached and the steps that are needed in order to have an all-hands-on-deck approach in order to arrest this situation. And maybe the time has come for us to engage in that discourse in the public domain so that no one can say that it's being done under a bushel. The other question I have before I go to Member Richards and then Member Dutch Media, you've spoken about the district courts and the district judges who would be in the courts. We know, for example, and we in the criminal justice system now, that there are masters now who filter, who do the pre-trial preparations. When a matter is sent to a judge, the judge goes into court and does a trial. Is there going to be a process where there will be more registrars in these district courts who would be responsible for doing the case management, the pre-trial, so that the district judge doesn't spend half its day calling matters and saying, well, what's the status here? Is the prosecution ready? Is the defense ready? Has disclosure been made? Are there any preliminary applications? Has any thought gone into doing that in order to bring down the backlog at the magistrate's courts? Because we have been talking here for hours and we're going into overtime, so please have your stamina. But there's most of the matters, in fact, all of the criminal justice matters start in the magistrate's court, including indictable matters. What is the plan, or what are the plans for that?
We've actually been having a lot of discourse in that particular area. And there are various options being looked at. One is, for example, separating the workload into case management magistrates and hearing magistrates, and arranging the dockets accordingly. One is, as you said, putting more to magistracy registrars, etc. So there are some options that are being looked at, and it's under very active discussion, as a matter of fact.
As we've engaged in it, it has come to my mind, committee members, the age of retirement at the magistracy, is it 60 or 65?
It is 60.
60 is the new 80. Why can't we? 80 is the new 60. Which one is it? You know, Joseph Appeal Kanglu once told me that math was not my forte. Is it that 60 is the new 50? 40. Good. Here is what we do. Can we not bring back these persons who have all this experience? They're 60 and the state has invested. We've had good training, good health. Bring them back to do the case management. Case management is now being done virtually. We don't need to go into courtrooms. Between 8 and 9 before the sittings, they have an hour, maybe an hour and a half. Do the case management. And then the itinerant magistrate, they get to do their trials. So when they come in court, the witness is in the box by 5 minutes after 9, and they do trials. Wouldn't that reduce the backlog, which will assist in the amelioration of this criminal justice system. Your thoughts?
Well, there are two things that you said there. One is about the retirement age of magistrates. But you know, you do bring magistrates back on contract.
Cool.
And at present, for example, I think there are 6 or 7.
7 of them.
Magistrates who are back on contract. But what you have explained there is exactly what is being considered when we talk about case management magistrates and hearing magistrates. Not necessarily with those who have come back on contract doing the case management, but just identifying persons to do case management and charge cases, etc., and then others to do hearings of managed matters and be able to start at 9 o'clock.
Thank you. Member Richards.
And it's of the public in terms of the role of the judiciary and the importance of collaboration while staying within the ambits of the separation of powers. Independence is not exclusive to collaboration, is not exclusive to independence. They can stay together because once there's the understanding of the separation of powers and the parameters within which one must operate. Also, you were very passionate about the issue related to children and angry children. Angry children don't fall out of the sky or evolve in a vacuum. Angry children come from an angry society. So we must understand where they're getting the anger from if we have to start the discussion. They don't just get up one morning or be born and 5 days after they're angry or at 7 they're angry. They're angry because they're experiencing anger on a daily basis through several different media. All right? I have to creatively merge these two questions to escape the wrath of the chairman.
Richards, ask your 2 questions.
It did not escape me that in your opening you spoke about crime rate, domestic violence, which you separated, criminal caseload, low rate of completion, etc. And several other parts of your presentations, you mentioned domestic violence. I don't think that was by guess. There's clearly some sort of pattern that you're seeing or trend why you identify domestic violence is in so many areas, and Senator Lashmidi also raised it in terms of the types of issues that arise in dealing with these cases. Part A of the question is, what are the main challenges that you're experiencing or you're seeing, given the data and the matters coming before you, in terms of processing and disposing of domestic violence matters, understanding the sensitivities involved? You mentioned earlier on the issue of electronic monitoring devices, because one of the considerations here is the protection of the victim. In some cases, the victims are dependent on the perpetrators, so it complicates the situation, and there are emotions and other factors involved here. So what are the factors that you're seeing that are impacting the disposition of or the completion of those cases? And in the case of the perpetrators, it goes to the issue of restorative justice. You also mentioned a while ago about the situation regarding having the need for more effective rehabilitation and restorative justice system. But can we have that if the matters take forever to be completed? 1. 2, you're mixing, not calling domestic violence cases softer cases, but you're mixing all sorts of criminal elements together. In some cases, learning from each other and learning, unfortunately, criminal skills. And also the conditions under which they are held and the protocols of rehabilitation are not seemingly being effective, because the recidivism rates are evidence to that. So if we had effective rehabilitation and restorative justice, we wouldn't have as high recidivism rates. So 2-part question there. If you could start with the domestic violence issue, because I'm really eager to hear about what the challenges are with that, given the sensitivities, and clearly you've highlighted that as an issue of growing concern by the judiciary. Please.
A key challenge is a domestic violence victim might go to report a crime that they experience in DV. And what happens a lot, even though it may involve violence, they are directed to the court to get a protection order, rather than action being taken to address the violence that is occurring, that is possibly a crime. So that's a key challenge. So they come to the court for a protection order. The other challenge, of course, is service. Yes. And so we have to try to assist not just in getting protection order, but sometimes shelter, because they're directed by the TTPS to come to the court for protection order. I lost my train of thought. Right. The other thing I was going to mention is the issue of service and getting the summons served. That is a major issue for us. And we have to depend on the TTPS for that. Yes. One of the things you also mentioned is the issue of electronic monitoring. The legislation right now does not appear to allow for electronic monitoring in terms of the perpetrator. So it would be voluntary rather than the court imposing that on them. The victim could agree to wear an electronic monitoring device, but I don't think the legislation allows for that right now.
I don't know if Senator Lashmidial can intervene, because I think we worked on that. And,
actually,
and it may, I could stand corrected, but one of the considerations was that victims are in danger when reporting the crime, and the immediacy of the concern is what prompted the inclusion of that option, so that the police could be alerted if the alleged perpetrator came within X meters of the victim, etc. That was part of the consideration, if I'm not mistaken.
Certainly discussed, and I'm a bit taken aback too, with some of the interpretations that you were saying you were hearing, because again, I was intimately involved in the case for bail, and one of the things that the electronic monitoring unit put forward was really just that they did not have enough bracelets to do it, but
Yes,
not that they were prohibited.
But not that they were prohibited, in fact.
So I'm a bit confused. So I think that is certainly something we will have to investigate further.
So one of the things that we're doing as well, because we do have a DV committee, and we are looking at some of the things that we feel we need amended, some amendments. So that would be one. And the second thing would be the way the act is written, it doesn't really allow the court to do certain interventions in the way that we would need to do interventions as it relates to perpetrators.
And have there been interventions or requests from the court for more electronic monitoring devices?
I know we have been using the monitoring devices generally for children as well as in the district and district court. But I know there was a problem with the number of devices. Yeah.
Chair, I would put my question, and I would be happy to receive it in writing, because I think it's complicated.
Yes.
But I just want to say, as a prelude, it's heartening to hear the level of understanding coming from the judiciary about some of the problems, particularly with related to children. I started my career in the DPP's office, and of the hundreds of files that passed over my desk, I've never seen a perpetrator of a crime who wasn't a damaged child, had grew up to be an adult. Hundreds of files. Every single one of them suffered abuse, sexual, physical, learning disability, something. It was something that started in childhood. So I'm happy to hear that there's that level of understanding. Master Morris Allen, if I could vote for you, I would vote for you for saying all that you've said today. It really is heartening to hear that you all have that level of understanding. Do you believe, and you could, again, assess this on a whole, but I'll give you some examples, but do you believe that there are certain agencies, units, or agencies within the system that need to be either merged, reassigned, or restructured to assist the judiciary in fulfilling its mandate. And I'll give you an example. Should electronic monitoring reside with the TTPS so that when the TTPS is dealing with bail, they know how many devices they have, what they can use it for, etc. They can do the investigations into suitability as opposed to some unit sitting in the Ministry of National Security. Should social services, should there be an allocation for the judiciary to be able to manage social services so that you could design and implement the interventions that you see appropriate, as opposed to having to go to the Ministry of Social Development and their unit, which I think is a unit that appeared before us here, to ask for resources and ask them to then design the programs. Do you think that the judiciary should have more control over those things so that you could be able to implement them more effectively and be more responsive to what you see coming before and the cases coming before you? I say these things again because it's been my experience where, for example, a judicial officer wants to make a particular order and the police who is there to assist the court may not be in a position to advise as to what is available. So perhaps if the judiciary would want to manage those things. And tied into that, you can, in writing, answer, do you believe that financial autonomy, full financial autonomy for the judiciary would better aid in the delivery of your mandate and improve and enhance your ability to fulfill your role within the criminal justice system? So I'd be happy to take that in writing.
We'll take the answer in writing, and just as a supplement, the public, the viewing public is very much tuned into this matter, and a question, I don't know how they got to my phone, coming from the public. Should the judiciary have its own marshal under the command of the Registrar of the High Court, and this will act as an agency? They would have uniformed and non-uniform sections, and it will serve all indictments, summons, protect the judges, serve in the courts, and it will, in other words, they have their own arm that will do its work for it under their own purview, which will allow the police to do what the police is there to do, protect and serve, and detect matters and bring them to the courts. Could you supplement? So there's a part B to that, and that is an answer that we'd like in writing, please. Member Webster Roy.
Thank you, Mr. Chairman. My question is for Mr. Gordon. Mr. Gordon, in your presentation, as part of your way forward, you mentioned that a paradigm shift is required. Resolution, not trials, and then you use the reverse telescope. Now, we all know for this paradigm shift to occur that you will need the buy-in of your key stakeholders and the public. How do you intend to go about getting that? Because we know how Trinidad and Tobago could be.
Thank you very much. I think one of the main challenges is understanding. And I think that what we are doing here today really helps people to recognize that the work of the criminal justice system does not reside only with the judiciary, but all the players. And as I mentioned, I think earlier, it's not, the race is not served well if one leg of the race is run quickly and run well, and other legs turn into a walk and a slow walk, and we're going to lose the race or a complete halt. And so I think that is extremely important. I think also the options that are available should be made known to accused persons so that they don't simply, as Master Morris Allen mentioned earlier, it's not about a poker game. It's an understanding that, for example, the use of maximum sentence indications. If I understand that if I am guilty, in fact, and I pursue the maximum sentence indication application and realize that the maximum sentence for me is a certain number of years, in some cases it actually makes sense because persons have been spending time on remand already, and they may discover that after applying for an MSI and finding out what the maximum sentence is, they may have served that time already. So I think the options, it's about education. Education for the accused persons education for the public. I think that's a key component in being able to move this forward. My day in court does not necessarily mean I have trial. It means my opportunity to speak, but moreover, my opportunity to get closure and yeah, thank you.
Member Sukai.
Chair, thank you. And again, team, thank you so much for your time. I have two questions, basically for written response, so at your leisure. Since COVID-19 and we transition into a more virtual-based court, I believe we have some submission here from the Law Association highlighting some challenges concerning these virtual courts, right, where they're saying that sometimes the public not here, and as the current bandwidth doesn't support, and then there's also matters sometimes are not listed and stuff. Given these issues, right, and I'll submit the question, and you could always respond in writing. Also, does the judiciary think that hiring lawyers to prosecute matters in the magistrate or district court instead of the police prosecutors, would this be able to assist in increasing the efficiency in the system, right? And for oral, I'll ask, I know you're talking about, decentralization of Port of Spain in terms of all the matters that go in there. Currently, the Shogunas Magistrate Court, do you believe it has outgrown its current capacity?
Yes, it has. And that's a fact. So, but the thing is that that was the one for audio or response. Yes, it has outgrown it, but the fact that we have been doing the decluttering means that it can be used to play a particular role. With the districtization and the decluttering of the magistracy, right? You will now use facilities as they should be used.
Thank you.
To answer the issue that was raised by both Member Richards and Member Lachmidial, it seems that Section 10A1 of the Electronic Monitoring Act, where an order for protection is made under any written law, the court may inquire of the applicant whether that person consents to being issued with a protection device. Where an applicant agrees to be issued with such a device, the applicant must complete the form and then will be responsible for that. So it seems that the legislation is there, and I suspect that that will be used in instances where the applicant, so the applicant here / victim, alleged victim, is, so but it's there for some sort of protection. There's another view that I have, but I will hold that view. Here is my question to you. In your submissions, and this one stuck with me, as part of the solution to the backlog in the criminal justice system, you stated the abolition of preliminary inquiries. What do you say to the submission that the preliminary inquiries have been there since almost time immemorial and therefore ought to remain, and maybe according to which side of voice you adhere to, maybe an erosion of due process? What is your response to that, Judiciary? Because that's your submission, that it should be abolished.
Yes, we actually think it should be abolished. I think it's extremely important that it's abolished. What do I say to that submission?
Why? Yes. What do you say submission that you're removing a part of due process? Well, how do you answer that?
You're not removing a part of due process. You're still having due process. The nature of it and the design of it and the flow has changed. But you're not removing due process. You're still coming to court. As a matter of fact, you're coming to court, you're getting before court faster. And so therefore, with the sufficiency hearing built in, and some other changes as well, even to the amendment that we have asked for. The point of the matter is that you will have good off-ramps, better off-ramps, and you will have an easier move towards that goal that we have of the reduced number.
Would you, and without asking a leading question, would you say then that the rationale for preliminary inquiries, it's no longer there and it has outlived its useful purpose today?
Most definitely it has, and as true counsel, you have started your leading question by saying without asking a leading question. But the point of the matter is, yes, it has outlived its usefulness. It wastes time, it doubles the time, it doubles the cost.
It doubles the fees?
Yes, it doubles the fees, and it doubles the costs.
Fees at the preliminary inquiry, fees at the trial. Madam, there's a question, and I put it in one before we wrap up. Over the past years, there's been the implementation, there's now virtual trials, judge-alone trials. You can now elect to have hybrid trials. Persons can appear at VAC centers. There's now the Omera complex. There are now the district courts. What else you think from, and I don't want, and I'm not politicizing it, so from an input point of view, can be done to improve the criminal justice system from the perspective of the judiciary? Tell us, what else is required? Because we want this system to be fixed.
You mean the court system?
The court system.
The court system?
Yes.
A commitment by all involved to advancing the case flow and moving with good case flow management. So it's actually now a question of commitment and all of us deciding to work towards the goal.
We take that, and I'm sure you mean without a toll, as we have just discussed the abolition of the PI, the preliminary inquiries, without eroding the concept of due process. Correct? Mm-hmm. The judiciary, this committee, thanks you. Profusely, the country thanks you genuinely, because this is indeed an historic occasion where you have come and you have laid out the hierarchical structure of the courts, the system of the courts. It's a long time. Remember, Lakshmi Dayal, I haven't seen stare decisis on show. Can we, I know you've labeled it, I see every slide has the judiciary on it, so we would have to ask you for the intellectual rights on it, because this committee would like to publish this and have it as part of our website to, yes, for public education. We take on board Member Webster Roy's request that it be done in a way that is even friendly for the children, because we want to put that in the schools and tell them when I'm not sure for TikTok, but in other words, when you become a lawyer, this is what the system that you aspire to. We want to genuinely thank you for your, and when we have unanimity, it is really something that we applaud you for, and we've gone into overtime, 3 hours. This may be one of our longest sittings under my tenure as chairman, but we want to genuinely thank you, and we want to say that we want to have an open discourse as we try to develop as a country into first world status. We want to have an open discourse without any hint of anything occult occurring, but transparency. And we have seen that a lot of thought went into this, and it was well thought out also, and we cannot say thank you enough for coming before us this afternoon and making the presentation. And the questions were very incisive from all members. Everybody were on their P's and Q's today, and we want to thank you very much. Would you like to make a closing remark, Madam?
Yes, thank you very much, Chairman. Actually, I would like to say, without a doubt, my pleasure. Today has been, as you said, a historic occasion, historic day, and I would hope that we move forward in such a way that the arms of the state can speak and can interact, and that we find the mechanisms for us to interact appropriately. I very much thank the committee for understanding and for designing the hearing today in such a way that the judiciary's representatives could feel comfortable to attend and to have this discourse, and for it as well to be such a pleasant experience. So thank you all very, very much. Thank you, Chair. Thank you very much.
For the country, you can now do an entire case paperless. It's a tutorial, a case line tutorial that is outstanding to me. For the country, you can do an entire case now paperless on case line, and I've been promised a tutorial because I was challenged electronically. I will say no more. Thank you very much. We look forward to the answers to the questions. Can we, because we're on a very tight leash in terms of time, because we want to submit our report before the closing of this parliamentary session. Madam Secretariat, you're saying 2 weeks? Can we have the response in writing in 2 weeks? We know that there are other things that are pulling at your resources, but you are very well equipped. Can we? We will send the questions. We will outline it in a letter form, and we will ask respectfully that we get a response within 2 weeks, please. Yes?
Yes, Chair, I think we
Thank
can
you
do
very
that.
much. We will now adjourn the public hearing of this 24th meeting of the Joint Select Committee on National Security. We are adjourned. All of this is yours, yes? Right, we did well.